well-known families in the history of South Africa, and we had no issues. We were happy that we were going to work together in peace.
That is the first meeting.
That's in our first meeting, even
Yes.
before Mr. Botes.
And I think the
came
first
in.
meeting was
I think it's on the 9th of November.
I think, yeah, it was on, I think Ms. Ngoye says it was on the 9th of November.
Let me confirm with my record. Yes, it's year date.
And the second one was on the 14th.
9/11/17 at Prasa Mathangoye, Fani Dingiswayo, and then we were also with the then acting group legal group chief executive officer. My notes here says we talked about the appointment of Werksmans, what they should give the board with regard to the appointment of Werksmans, and then the discussions. We talked about how Werksmans was appointed according to them. We talked about the report of the public protector, as well as the report of Mkabele Huntley, and we were to continue our discussions. There was no mention of Siaya because even me, I didn't know anything about that at the time. And then we adjourned our meeting that we'll have a follow-up meeting. The second meeting is on that date when after Mr. Botes came, then I called them again because I was sitting with the group CEO. Then we discussed the report of that we were just reading, Chairperson. And in my statement, I mentioned, or not if it's not statement, in my memo, I mentioned that Ms. Ngoye appeared to have a faint idea about the insolvency inquiry. So, Chairperson, that's my first encounter with them. Maybe I can stop here, but I will elaborate.
Yeah, let's go back and start a little earlier.
Yes.
Before your appointment as chairperson of the PRASA board, you had been practicing as an advocate since 1999, is that right?
Yes.
Yes, and in October of 2017, you were interviewed by the Judicial Service Commission for appointment as a judge, is that right?
That's correct.
Was the interview on the 4th, or what was, are you able to remember the actual date? You can't,
I can't remember.
Early in October.
I can't remember of it, but it's usually first week of. First week of October.
Yeah, it's usually first week of October. I think it was first week of October.
3 or 4 October.
Yes. Now, you had been nominated for appointment as a judge as far back before October as when? In other words, when were you nominated, or when did you put in your nomination documents? Would it have been around July?
I think the closing date was maybe July.
Maybe around July.
Maybe around July.
Yes, yes. I take it that at that stage you had made up your mind that you wanted to go to the bench, if you could be appointed to the bench, is that right?
Yes.
Yes. And then you had the interview, I think it was on the 4th, if I'm not mistaken, of October,
Maybe
from what I've read.
4, but,
yeah. Now, you were recommended for appointment. The JSC recommended that you be appointed as a judge, is that right?
Yes.
And when did you get to know that that would be their recommendation? Was it like a day after your interview or a few days after the interview?
It's usually
quite soon after the interview.
It's normally not days. It will be maybe, it will be the next day.
It would be the next
It's
day.
not- it's-
That's
it
my
doesn't
experience
take-
as well.
It doesn't take long.
Yeah. No, that's my experience as well, that you either hear on the same day of the interview or you get told the following day.
Yes.
It doesn't take long. So we can take it that at least by the beginning of the following week, after the interviews, you knew that you had been recommended for appointment.
Yes.
Excuse me. And at what stage had you been approached for possible appointment as a director of the PRASA board? When you went to the interviews, had you already been approached or not yet?
It must have been, I'm trying to think about the date because I have these things in my, I have already drafted some statement to respond to this at some forum. Where, remember the
Oh.
remember the JCC?
At the JCC,
The JCC is already
has had a
it's-
meeting with you.
It's actually considering that very issue, the question
Yes.
that Chair is asking me, or where you are going to.
Yes.
Why did I go to PRASA when I had already been nominated to practice
Yes.
for the bench? And my
Yes.
answer, Chair,
Yes.
is I will give the date in I will reduce that statement into a sworn affidavit. If the reason I didn't-
Don't speak far from the mic.
Oh,
Because
sorry.
when you speak, when you are a distance away, I
the
can't hear you.
the applications to the JSC are closed maybe 4 months before the interviews. And my recollections is the approach to serve in the PRASA board was in September.
Was in September.
Was in September.
Okay.
Yes, was in September, and definitely before the interview. Yes.
And who approached you for possible appointment to
There's
the
a
PRASA board?
there's a neighbor of mine who obviously, if you know each other, you hear about opportunities, and then you even among circle of friends or even family. So he was a neighbor. He said he had the Minister of Transport would be constituting interim or temporary boards because he is under pressure. I think there were some court applications for the minister to constitute permanent boards. But then apparently he wanted to constitute interim boards when he was in the process of constituting permanent boards. And then I then said, look, I've already decided that I no longer want to practice. And I want to go to the bench. I have submitted an application, and if I am successful, I will, between this and the bench, I will choose the bench. So he said, anyway, give me your CV. Then I then gave him my CV. I will, if chairperson wants this communication, because it was SMS and email,
Yes.
I will give it to you.
Okay, no, that's fine.
I will
That
give
might
it.
be helpful.
I
Or
will-
maybe you can include it in your,
I will include it in
Bundle. Yeah.
my statement.
Yeah.
So I gave him my CV, and definitely before the JSC interview, and then we forgot about it.
Yes.
And
Are you
then-
able to give the name of the neighbor?
It's Mr. Chauke.
Mr. Chauke.
Chauke, yes.
Yes. And what is the name?
His name is Richard.
Richard.
Richard, yes.
Mr.
He's-
Richard Chauke.
He's a doctor now. You can call him doctor.
Or is that a medical doctor,
No,
academic doctor?
The learned doctor. He's not a medical doctor.
Oh, he has a doctorate.
He's a doctorate.
Okay,
Yes.
no, that's fine.
I understand those are the real doctors.
Well, I'm sure the medical doctors
I mean,
will
for
contest
the title, chairperson.
or for the title.
The
Okay.
title belongs to those who have a PhD. I'm told.
Yeah.
The medical ones, it's a job.
Yeah.
I'm not saying anything. I'm just
Yeah.
yes. So I will
Okay.
give you the
Yes, you will just.
the trail
Yes.
of that correspondence.
Yes, okay. That would
Between
be
the two of
helpful.
us. So
Yes.
then I went for an interview, and we didn't talk again about my CV.
Yes.
But what I understood and what he said in return to the communication that I submitted my CV was that he was going to forward it
Yes.
to the department.
Yes.
And I didn't hear anything from anyone. I didn't until I think on that day was maybe 23 or 19 October. Then I just heard people saying my name was mentioned on television when they made cabinet announcement that I have been appointed in the PRASA interim board of control, and that cabinet has endorsed the names. And thereafter, then I received the call from the department. Then I indicated that for how long is this appointment? Because one other thing, Chairperson, before you, maybe that will be your next question. I don't want to, I'm not anticipating your questions, but because this issue has been raised.
Yeah, it's been.
So
yeah.
I know the issues, the concerns.
Yeah.
So I'm not anticipating.
Yeah, no, that's fine.
Your question.
Address it, yeah.
Yes, before I went to the interview, before I even submitted my application, and
That is Judge President Lambo.
Lambo.
Yes.
And then in the course of our discussions, obviously, is to establish your readiness. And I think I did mention in my interview that he's the one who was persistent that I must apply, I must join, because I had been acting a lot. Then I then said to JP, at that time I was holding the position of chairperson of the Water Tribunal, that if I'm appointed, I will have to give notice to the Minister of Transport, not transport, of water and sanitation, because I cannot simply leave. There's a stage where the Water Tribunal collapsed because the chairperson left for a judicial appointment without notice, and then when we were appointed, obviously we re-established the tribunal. So I said I will at least want to give notice of about 3 months. So I was very clear from the beginning that when I get the appointment, I will first have to give notice from the Water Tribunal, and that was our understanding. So when I accepted the interim, to serve in the interim board of PRASA, it was on that basis that anyway, I have time that when I'm finalizing my work, other than the water tribunal, there were other matters that had been set down well into November and some into February and March of 2018, so that this thing will fall within that, because I was told it was going to be, the minister was given 4 months to constitute a permanent board. So people are always asking, where does this date of 1 April come from? Because that's the date that I had indicated I would be ready to start with my judicial appointment, chairperson. So that's how it went. So when the announcement for that the president has approved the recommendations, that came after I was already at Brass.
I'm sorry, just repeat that sentence. I didn't hear it.
When the president made the appointment.
Yes, okay. To appoint you as a judge.
Yes, I was
Yes.
already at Brass.
Yes.
Yes.
Because you were appointed as chairperson of PRASA
19 October.
on the 19th of October.
Yes,
And the announcement by the of the decision of the president in terms of appointing various judges, new judges, it seems was made on the 2nd of November, or at least early November. Is
I
that your
think early
recollection?
November, but I
Early
was
November.
already at Brass.
Yes, yeah,
I
you
was-
were already at
I
PRASA.
was already at Brass.
Yes, yes.
So then when that announcement was made, then that we all starting on the 1st of January, then I then engaged the judge president.
You what?
I engaged the judge president,
Yes.
Mlambo, about it. I will provide chairperson with, because I mean, there's no longer a secret. Everything must be, whatever is available, we have to provide. I will provide our communication, because I was expecting that my appointment
Yes.
would have a date of 1 April,
Yes.
not 1 January. So JP, even before the president signed the letters of appointment, he issued a notice to the recommended candidates, of which I was one. The directive was telling us that he was congratulating us for having been recommended, and saying that usually from here the president will sign the certificate. He has asked him to sign for the 1st of January, but usually the president will take time, but even if it takes time, the appointment gets backdated to the date that he has given him. And he also was explaining some other logistics, appointment logistics. And I immediately wrote to JP by return email to say, well, I accept that you want to place me in Pretoria, and ask other questions. And then I said, but JP, with regard to the date, can I have a discussion with you? Remember, we had a discussion. I want to meet with you with regard to the effective date. And remember, Chair, by then the president had not yet signed, then according to that letter. So JP said to me in reply, Nana, I'm busy. Put your thoughts about the effective date in writing, which I did by return mail to him to say, JP, you remember we agreed that I want to start on the 1st of April for these reasons. And then we further exchanges between us, and And apparently, in between, maybe because of my delay in responding to him, because in one email he said I responded late. The president has already put the date of 1 April. And then we had further meetings with the JP and until we came to the understanding that he will engage the Minister of Justice to ask the president to change that date to as I had requested. And obviously I had to ask JP, but JP, why did you not give the president from the beginning the date? And then his reply was, no, he received many requests. Late
Don't speak away from the mic.
many requests, and then he wanted, I don't know what but the long and the short of it was that he did not communicate that date to the president at the time when he made that submission, and that's the story, Chairperson. Yes, I will provide the documents that I'm referring to from
Well, the commission does have some correspondence from the JP. It's not in the bundle, I think, because it came recently. We asked the JP for the letter asking for or recommending a deferment of your appointment, to say it must be at a later date. But we have got that letter, and then we've got a letter from Unite Behind, I think, if I'm not mistaken, that Unite Behind may have written, I don't know whether to you or to the JP, about their concerns in regard to you and PRASA. There may be a letter that you either wrote to the JP or wrote to Unite Behind. But we wanted to see the letter that went to either the minister or the president saying your appointment must be deferred.
I have that correspondence.
You have got that correspondence?
I have that correspondence.
Yes.
Because immediately Unite Behind started writing to JP Mlambo in end of January 2018. Towards end of January, they said, there's a judge, one of your judges is at PRASA, and according to the court roll, we see she's also sitting in court. A judge cannot hold dual positions. And I think that's when they engaged with JP, responded to say, no, she has asked to start 1 April. I've already asked the minister to ask the president to do this. And that's where it started. I have the correspondence, the first and even the correspondence that JP sent to the minister subsequent to that. I also have, because a legal controversy developed. The controversy was whether that date of 1 April can simply be changed. and then, but then President Zuma was gone. It was President Ramaphosa. So the state legal advisors sought an opinion, which President Ramaphosa wanted, whether he lawfully he can grant that change. I have that opinion because it concerns me. They provided me with that opinion, and I did not even start on 1 April. because now the controversy grew bigger and bigger and bigger, and then the president wanted to make sure that before he changes that date. So I stayed home. I'm no longer at PRASA because I resigned at PRASA. I'm no longer at PRASA. I'm no longer practicing as an advocate. And
When did you stop practicing as an advocate?
I on the end of March.
End of March,
End of
2018. 2018.
2018, yes.
Okay.
Because I was still even appearing in court.
Yes.
And also doing water tribunal
Yes.
work.
Yes.
So my effective date.
Well, after we got the JP's letter or correspondence, and we saw that what was said to the minister as the reason for the deferment was, I think, the work at Water Tribunal. The commission made contact with the Water Tribunal about the work that was to be done as well. You said there was some work to be done there.
I did some sittings at the Water Tribunal in the month of February, and I will give you a copy of my letter of resignation.
Yes, yes.
But there was work that I was doing at the Water Tribunal on specific dates, which I will provide you with.
Now, if I recall correctly, the correspondence I saw seems to suggest that there was an appeal which had been heard on a number of days up to the end of 2017, but the judgment had been reserved and it was handed down later at some stage in 2018, I think mid-2018. But in terms of sittings, the correspondence suggested that the sittings were only in 2017. Would that be your recollection?
No, I will give Chairperson the details.
You could give a full account of what was there.
I will give you a full account of what was there.
Yes.
And which matters
Yes.
set on which date.
Yes.
And when the controversy arose, because it was clear I was not going to be working as a judge on the 1st of April, I then asked JP and Minister Masuta, I was writing to them to say, please tell me, am I still going to be a judge, or can I just forget about this and go back to practice? Because JP's position was that he can't risk putting me on the bench before that controversy was resolved. And I remember there was I had been, DJP Didwaba had put me in the recess role of April of 2018, but JP Mlambo said, no, I can't until that controversy is resolved, because there is that certificate of appointment which we don't know whether it's valid or not until we hear from the president, and he can't appoint me to sit on the bench on an acting basis. So I did nothing in April. I did nothing in May, and then mid-May, then President Ramaphosa made a decision. I don't know if Chairperson has copies of the decisions.
I think I've seen at least, I don't know if it's a letter from the minister saying the president made a decision which I understand to be the effect of which I understand to be that you were going to start on the 1st of June, or you were being appointed with effect from the 1st of June.
Yes.
Of course, it's a little confusing because you had already been appointed with effect from the 1st of January.
Yes, but
And then now the letter
1st
says
of
you are
June.
being appointed like again with effect from the 1st of June. I found
well,
it confusing.
maybe what Chairperson missed is the proclamation
I'm
by
not-
the
I'm not
president. There's a proclamation that
The
says,
presidential minute, I think.
presidential minute,
Yeah.
that says, I had previously appointed you with effect from 1 January. And now I'm changing that date to 1 June. And then there's the appointment certificate. Yes. So
Yes.
that's
Now,
what I say, maybe you did not see.
yes.
Yeah.
Now, the letter that was written by the judge president to the minister about the deferment of your appointment certainly says, in effect, it's because of your work at the water tribunal that you were seeking the deferment. Is that correct?
I don't think it says so.
Or maybe I should ask,
I-
what is the reason
I
that made
haven't-
you
I
ask for
haven't-
the deferment?
I haven't seen that, Chairperson.
Oh, okay.
I said when I asked to defer, it was to finalize my work. I still had matters set down up to the beginning of the next year.
Yes.
And secondly, it was to resign from the water tribunal, give notice until 31 March. And I said, the PRASA issue is something that happened. Because I want to make it clear, Chairperson, I did not, JP Mlambo didn't give me permission to go to PRASA. No, he did not. I already said that when they said the appointment will not be longer than 4 months, I said, I can do this because anyway, I have time. So it was an economic decision, like I was still practicing, going to court, doing everything that an independent legal practitioner could do. So when the opportunity came, I said, I can do this and then it will be finished before my due date to start with the...
I saw in, I think, your statement or letter to the Bar Council in relation to your complaint against Mr. Portas.
Yes.
I saw that you indicated that you had asked for the deferment of your appointment in order to wrap up your practice.
My practice,
is that
yes.
correct?
I have it here, let me...
Yes, I think I did see something to that effect.
Paragraph 1, I say I was a member of Pretoria Society of
It won't be.
I resigned from membership of the bar with a view to prepare for taking up judicial appointment. My appointment would have been with effect from 1 January. However, I requested an indulgence of 4 months to wrap up my legal practice. So it was, I just generalized it.
Yes.
So, and then I say I would have commenced duties on 1 April, but the date was amended to 1 June 2018. I took oath of office as a judge on 8 June. Thank you.
Well, part of the concern I have is that in the letter to the minister asking for a deferment, the reason that is mentioned, and I assume that the JP mentioned it because that's what came from you, was your water tribunal commitments. But in this statement, it says it's wrapping up your legal practice. It says nothing about the water tribunal.
I haven't seen that letter, Chairperson.
Yes.
Okay.
No.
I can't comment on it.
Yes.
But,
Okay.
But
Yes.
the request that I made
Yes.
was to wrap up my legal,
practice.
including
Yeah.
the water tribunal. That's
Yes.
that's part of my legal practice.
Yes.
So I don't see the contradiction, Chairperson.
Yeah. You see it as
Yes.
the water tribunal is part of your practice.
Yes.
Yeah. Okay.
I was appointed when I was not a full-time, it wasn't a full-time job. It's a chairpersonship where you are called to adjudicate matters, as and when there are matters. And whilst you are doing any other work that comes your way as a legal practitioner. Yes.
So you say after, and I think you said you resigned from the bar with effect from the end of November, is it right? And then you continued practicing
Membership,
after
yes.
the membership of the bar.
Because you can practice as an advocate from
Yes.
your house or anywhere.
Yes. No.
But
I understand
membership
that.
of the bar,
Yes.
I resigned.
You had resigned, yeah.
Yes.
But you, in terms of your practice,
I
you
continued.
continued, yeah.
I
At
continued.
that stage, you were no longer keeping chambers.
No, I was no longer keeping
You were
chambers.
practicing from home.
I was practicing from home.
From home.
Yes.
Of course, I guess you must have had quite some work, because if you defer your appointment as a judge from 1 January to up to
April.
end of March, it means you would be forfeiting 3 months' salary as a judge. So your practice must have been. you
Well,
must still
compared to the matters that I had already scheduled. It was worth it.
It was worth it.
It was worth it because I had court hearings.
You had court hearings.
I had court hearings even in Pulukwani, High Court Pretoria. I was still consulting, and the tribunal, we are paid per sitting. And as chairperson, there's a administrative work that precedes sittings, because you are the one allocating matters. You are the one, allocation means you must have read the files and everything. So it was, and it was really not about money. It was about putting my life in order, that I want to close this chapter. I still have matters. I still have accounts to render, and I must do this. Let me defer my appointment. So I forfeited judge's salary for not just those 3 months, but because the appointment was delayed further for 5 months. So,
But of course, when you
it was no longer my choice. I was simply not in a position, because I couldn't now assume duties, because I was told the certificate must first be changed.
Now, tell me, in regard to your position as chairperson of the Water Tribunal,
Yes.
what was the notice period you were required to give? Was it 3 months, or in terms of the law, or what was the?
There's no specified notice.
There's no
period.
specified period.
I chose to give that
Yeah.
because there were a lot of outstanding matters, Chairperson, and as I said, I didn't want to disrupt the tribunal, because if there's no chairperson, there's no tribunal. And at that time there was even when it almost happened that on the 30, maybe towards the end of March, when I realized that this thing of changing the appointment date may not happen soon, I even considered withdrawing my resignation at the Water Tribunal, because I wanted to go back to practice. And I think there was that attempt to withdraw. I was no longer, I thought, let me go back and withdraw my resignation and forget about this judicial appointment. Yes.
In the interview in the JSC, did they ask you when you would be available to commence your duties as a judge if you are appointed?
No.
They did not ask you about that?
No. Well,
Yes.
I've seen, again, I'm not preempting your questions, but because Judge Tukten, he wrote a judgment, and then he mentions in his judgment that did she conceal the fact, some facts from the JCC? Was there something she should have told the JCC? Definitely no one asked me anything. I mean, the record is can be accessed. There were no questions that when are you available? Can you start tomorrow, next week, or when? And my understanding, Chairperson, and you should know, and it's a fact that can be established, that there are judges who asked and were given much longer than 3 months. So it wasn't, it's not there's nothing untoward about someone asking to defer their appointment. It has happened. And there's nothing, as far as I know, there's no rule that you cannot ask. There's no rule that once you are recommended, there's a specific date that you must start in. And in my interactions with the Department of Justice, because we had a lot of interactions, and I will mention it in my statement, and also refer to the people that I was consulting with. The logistics of the appointment are with the head of a court, because he knows when he needs capacity. And even we attend the same interviews, Eastern Cape, the judges would be required to start a month earlier, and in another division, maybe a different date. And my understanding is the JP gives the minister a date that I want my appointees to commence on this date. And from there it becomes an employment issue. That's the information I received, that in reality, the people doing the logistics of the appointment should be asking you, here is, when do you want to start? And then you say, no, I want to start next, when, and then you sign, there are forms to be signed for salary, for the declarations of interest and all those things. So my understanding from the information that has been provided to me is that that is allowed. And until now, I don't know, maybe the JCC, the JSC may want to do something about it, and because Unite Behind has gone as far as to suggest that once you are recommended, it means your economic activity starts. But they forget that the recommendation, as Chair has already said, it's soon after the interview. And the effective date of the appointment would be 2 months later, even if one were to take that appointment. But then who is going to support you in between?
Well, I certainly know that there have been occasions when persons who have been recommended for appointment as judges did not start or took quite some time before they started or before the appointments took effect. And I understand that some of them raised those issues in the JSC to say, although I've made myself available, I want to say that I won't be able to start like within the time that normally happens. I will talk to the head of court because I might want to make an arrangement for my practice. There have been those instances, but I don't know the details in regard to all of them. I just do know that there are some of those instances.
Yes, Chairperson. And the other thing is, I'm not aware of any prohibition that whilst you are under recommendation, let me put it that you are under recommendation, the kind of work you can or cannot do. I really don't know, because it was stretched to say I should not have gone to PRASA, but what should I have done? No one told me that you are now limited to doing this. If you have, you can't do that. I'm not aware.
You see, Judge Mkhwele, part of what makes your case strange, at least to me,
yes,
and I'm putting this to you so that you can address it, is that here is somebody who wants to be a judge. She has gone to an interview with the Judicial Service Commission. She knows that she has been recommended for appointment as a judge. She knows about her recommendation early in October. And around 19 October, she allows herself to be appointed as a chairperson of an SOE. It could have been maybe a private company, but an SOE in circumstances where she knows that in all probability she is going to be appointed, because I think we both know that once the Judicial Service Commission has recommended to, actually the Constitution says has advised the President to appoint you, almost invariably the President will appoint you. You know, there may be one or two cases that I'm aware of where there were some queries, but I don't remember anybody over the years who, in respect of whom any president was advised to appoint, to make an appointment, and did not accept the advice. So you're dealing with a situation where you are almost sure that you are going to be appointed, you'll go to the bench. It's towards the end of the year. It's maybe reasonable to think that the expectation would be that you would start early in the new year. So then the question arises, but why is she taking this PRASA appointment? Why is she taking on new responsibilities when she knows she is due soon to start her functions or her duties as a judge? Why is she taking on more responsibilities instead of reducing her responsibilities in preparation for going to the bench?
Well, Chairperson, the problem with that analysis is that there's an attempt to link the two the two scenarios, the non-taking up of the appointment and having gone to PRASA.
Not wanting to take on the judicial appointment, but wanting to take on a non-judicial appointment.
There's an ulterior motive, which is what is being. I don't know if I can only explain what I'm explaining, and then
Yes.
the complainants will be saying yes. The reason she did not is because she wanted to go and commit these irregularities at PRASA. But if you can separate the two issues, then you will see that they would not necessarily be linked, because suppose I had gone to PRASA and then under similar circumstances and I come out without any allegation of wrongdoing, no, there wouldn't be any controversy about it.
Well, to me, there would still be something strange about taking the PRASA job.
Yes.
Because, as I say, when you know that you have been recommended for appointment as a judge, and you know that soon you will be expected to commence your duties as a judge, one would expect you to begin to wrap up, because you know you are soon going to start as a judge. One would not expect you to take on more responsibilities. That's point one. Point two, these responsibilities, this was a position that would be seen as not consistent with being a judge, to say, but this person wants to be a judge, she has made a choice, she wants to be a judge, she knows she has been recommended, in due course she must start working as a judge. Why is she adding on another responsibility that has got nothing to do with judicial function?
I'm ready to answer to any suggestions that may be put as the reason, so I can, if I have to dispute the suggestions, but I have already given my how it happened. You know, you, Chairperson, you're sitting there with hindsight.
Yes, but I just wanted to address it again.
You're sitting there with hindsight, questioning the motives of someone who says it happened because I had time. I had time until end of March, as far as I'm concerned, and that in the period there was nothing to prevent me to have taken up the appointment. You know, if the suggestion or if what was being put to me was to say, you know, there's a prohibition that you cannot do this, then I will start to begin to say, to want to justify, to say, I did not know. But I'm saying, as far as I'm concerned, or as far as I knew, there was no prohibition, and I did that out of a need, and I'm telling you that I was still adjudicating matters at the Water Tribunal. It was not a full-time job. It was on a calling basis. And same with PRASA. It wasn't a full-time job. It was I'm already in this tribunal, and board to me would sound the same, that even there I'll go when I'm needed. There are meetings, schedules of meetings that we are given, and then that other side there's also scheduled, and then there are court hearings which are also scheduled, and I did not see any besides not seeing any conflict, I did not deem it as a job that chairperson would call a huge responsibility. And I will tell you, again, I'm not anticipating the questions, because I know the questions have been asked by everyone, even at the JCC. There's a ruling that Chief Justice and his committee have already made that of all the cases at PRASA, she concentrated on this CII matter, and I'm going to prove that I didn't concentrate on CII matters. And I, maybe not to you, but I'm ready to...
Yes, no, but I am going there. But let's deal with this first. I am going there.
I am going to prove that we did a lot at PRASA, and I will be happy to share what we did with you, so that you can see that there was nothing strenuous about it. I carried it, and I also carried what I had to carry at the Water Tribunal and also in court. So I am ready to answer that question, that other than CII, what did you do, Chairperson, if you want to get to it now?
Yes, no, I think we will, but let's finish on this. I'm surprised that you say you didn't see your position as chairperson of the PRASA board as a position that came with huge responsibilities. I'm surprised by that, because my own understanding is that indeed any position of chairperson of a board of any of these SOEs comes with a lot of responsibilities. But also...
Chairperson, can I correct you? I didn't...
No, before that, I'll give you a chance.
Yes.
Also, purely from what one has been hearing about PRASA in the public domain, even before this commission, the allegations of corruption and what's happening there, and of course I've had some evidence within the commission, but even in the years, some years back in the public domain, it was quite clear that there were lots of allegations of corruption at PRASA. And also, you may or may not be aware that your predecessor in that position, Mr. Popo Mlefe, has testified in this commission. My understanding of his testimony is that as a board, they had a lot of work to do. So my impression is that there was quite a lot of work. It was a lot of responsibility. That's why I'm saying that I'm surprised that your evidence seems to be that, no, it wasn't such a heavy job.
Well, you misunderstood me. The word that we were using was strenuous. And I said it was not a strenuous job. I did the job very well, and I will show you what we did. Yes, there was a lot of work. And I told you, the chairperson, that the second day of our appointment, we were called to Parliament, and we were given certain tasks to report, and we had meetings. So I didn't use the word there's no job. I said it was not strenuous. I was able to carry it. Yes.
So do you accept that the job came with a huge responsibility?
Yes, I do.
Yes.
I do.
You see, that's in part where my difficulty is namely that here is somebody who should be winding down in order to be ready to take a new position as a judge soon. But instead of winding down, is taking on a new position with a huge responsibility. That doesn't sound, that seems strange to me.
If Chair can tell me how strange it is and maybe tell me what informs your
Well, I
your
think that
worry,
once you know,
because we've been we've been on this, and I can't take it further. Chair will
Yes.
remain with the Chair will remain with
Yes.
the impression that it's strange, and I
yes,
can't, in the absence.
you can't say anything
In the
more than what you've
absence
said.
of
Yes.
you telling me what you think informed my decision to enable me to deal with your thoughts, whether they are, it's just your thoughts or the evidence that has been laid before you. I can't take it any further.
No.
Can I request I need to drink water, Chair, if I can have an opportunity to just get my water and drink it.
A comfort break?
I've been talking for long now.
Yes.
Yes.
Okay, let's take a 15-minute comfort break. I see it's 7:15, so we come back at 7:30, and then we'll see how,
Yes.
when we can adjourn.
Yes, thank you.
Okay, we'll take an adjournment for 15 minutes. We'll resume at 7:30. We adjourn. It's 7:30. We'll adjourn at 8. Yes. Yes. Counsel and judge.
Oh, sorry.
Yes.
Going to start afresh. The reason I asked what issues the commission is investigating, because I obviously need to know what I'm supposed to respond to. And yesterday, I wrote a letter to Chairperson. I'm not saying you have seen it yet, but you can just take note. It's 4 August 2020, where I requested certain information. And part of that information that I requested was that I see the witnesses before you have attached the judgment of Judge Neil Tupten. And in that judgment, he has made some adverse remarks about me. And he has also, one of the issues that he is dealing with is the issue of why did I what did I possibly withheld certain information, what was I doing at PRASA, and then he makes a recommendation that he is of the firm view that a platform should be created for me to answer the questions that he has raised. Some of the questions relate to the allegations of the settlement of the claims, but then again specific to the issues pertaining to my appointment as a judge and the very strange feelings that Chairperson says you have. And then he says a platform must be created for me. So in the letter that I wrote to Chairperson yesterday, I specifically...
I haven't seen that letter.
So
it might have,
I
might be on the way.
I specifically asked if this commission is that platform that Judge Tupten has suggested must be created, or what am I supposed to answer with regard to the judgment of Judge Tupten, which has been attached to the witnesses' statements, Chairperson. So at this point, my request is that and when we started, Chair said, no, you only dealing with the issues pertaining to the settlement of the claims. And I took comfort in that. But then now Chairperson is asking me questions about...
Well, I said the issues that we'll deal with are those that are in the affidavits in this commission. And then I mentioned the settlement, which is one of them.
Yes.
And actually, it occupies quite a big part of what Ms. Ngoye and Mr. Dingiswaye talks about. One of the things that Ms. Ngoye raises is that, the chairperson of the PRASA board had been appointed as a judge. Actually, when she took up the position, accepted the position of chairperson of the board of PRASA, she had already been recommended for appointment. She raises those issues in her affidavit.
Well, she makes statements. She doesn't raise issues.
Well, she is saying,
just
in
a
effect,
statement. The person that calls it's Mr. Ahmad in his statement. And I think when we deal with this evidence, I expect to address what he means by my controversial appointment. But then the issue that I'm saying, Chairperson, is in the letter that I've written, which you say you have not seen. Maybe if Chair can see the letter first, because I refer to the rules of the commission, in terms of the rules of the commission, if there are proceedings in any other forum that were conducted, be it. So in this case, on this very same issues, there's a proceedings at the High Court in Pretoria before two judges, Holland Mitter and Tukten. There are proceedings before the JCC where I've already appeared, and the rule 6.5 says a witness, well, I'm obliged, and the other witnesses are obliged to bring those to your attention, those proceedings, to tell this, and so that the secretary can procure the transcripts in those proceedings, Chairperson. So
Yeah.
which is what the heading of this section of my letter says terms of reference in PRASA hearings, because I in all honesty, I need to know that what exactly am I supposed to respond to. That's why I started by referring to the affidavit of Ms. Ngoye, where she says the people she's going to talk about are people against who have been found wanting. And I emphasized that I'm not one of those persons. No one has ever found me wanting or anything. But
Well, let me explain it to you so that we don't take too long on this.
Yes.
You look at the terms of reference of the commission, you will see that they include that the commission must investigate acts of state capture and corruption and fraud in the public sector, including the organs of state. As I said earlier on, many people know that for years there have been all kinds of allegations of corruption at PRASA that have been in the public domain. Now, the PRASA witnesses who have come forward have testified about allegations of corruption at PRASA. They've made certain allegations against the CIA companies in terms of corruption. They have made certain allegations against Mr. Mackenzie Mabunda, who I understand from Ms. Ngoye's affidavit controls the CIA group of companies. And they say, here is something that happened here. Somebody who had been interviewed for appointment as a judge and had been recommended for appointment gets appointed to come to PRASA. And she comes to PRASA as chairperson of the board, and she shows special interest in the settlement of CIA claims. And they say, contrary to what you say you will tell me, and you said you will give details, they say there were many cases at PRASA, but she only showed interest in the CIA ones. They said there were many others. She just wanted CIA claims to be paid.
Yes.
And they say she sidelined the legal department of PRASA, that is, people who have always been handling PRASA matters, legal matters internally. And they say, according to Mr. Mukhashwa, this chairperson tells Mr. Mukhashwa, don't deal with the legal department of PRASA anymore. And then they say the next thing, these matters are settled. And actually they say, when you look at the so-called settlement, it's not settlement, it's capitulation by PRASA. When you look at the amounts that the chairperson said must be paid, it's exactly the amounts that are claimed by the CIA group against PRASA. It's not a compromise or anything. And she says we had to intervene when there was a new Minister of Transport, Dr. Blaine Zimande. We had to approach him and say, Minister, there is something wrong. There is something wrong happening. PRASA is about to lose about, I don't know whether it's 59 million, but a lot of millions because of a settlement that the chairperson has pushed through. We are against it. Please allow us intervene. And then they go to court and they say, we succeeded ultimately to stop this. They say the chairperson had no authority to settle these matters. The authority was with the head of the legal department. And they say we successfully prevented PRASA from losing a lot of money that PRASA was going to lose because of this chairperson. And they say since we succeeded, the CIR companies have never pursued these claims, this arbitration that was supposed to go on. That's what they said. So this commission is looking into that to see whether exactly what happened.
Thank you, Chair. We will obviously get to the other details. You remember we just stopped where I had talked about the reports of the commissioner, and then we then we spent maybe the last hour talking about my appointment. But I'm going to deny everything that they are saying. I'm going to show you that I'm never one person that takes shortcuts. Even with the matter of Siaya, I will deny that it's my decision. And even with this Siaya matter, my board always involved the internal auditor. I have reports.
Internal auditor?
Yes. Mm-hmm. In every issue that we were dealing with that was required some, so there is, I will show you, Chairperson. And I think you have seen from my statement that my relationship with the legal team, not just my relationship, my board's relationship with the two incumbents of the legal unit broke down.
Why did it break down? Because as I understand the position from Ms. Ngoye, and I may be misunderstanding her evidence, but my impression is that you sidelined them and they were against the settlement of the CIR claims because they believed that PRASA had reasonable prospects of success. And as I indicated earlier on, Mr. Dingiswayo testified that he was told by Mr. Mahashwa, who was PRASA's attorney, that you had said the PRASA attorneys mustn't talk to the legal department at PRASA about the CIR claims.
Well, I will deal with it when I don't know what will happen first, maybe oral evidence or my statement, but I will deal with all that. But what I'm saying, Chairperson, is that maybe it's in their oral evidence.
It is also in their affidavits.
In the affidavit of Ms. Ngoye, she mentions...
Ms. Ngoye refers to it?
In her last paragraph, yes, she mentions that, she says, I may mention that the chairperson had been recommended as a judge, but she doesn't make any conclusions why that is relevant, Chairperson, which is why I'm asking whether there's a witness who has given evidence to say that I went, let me not say whether, because there is a witness, maybe we can talk about him, Mr. Botes, Advocate Botes. Advocate Botes is the only witness.
Well, let's leave Advocate Botes for now.
Yes.
Let's come back to Ms. Ngoye and Mr. Dingiswayo. What do you say to Mr. Tingosoyo's evidence that he was told by Mr. Muhashwa that you had told Mr. Muhashwa not to discuss the CIA claims with the legal department. And of course, you will have seen in Mr. Muhashwa's affidavit that he confirms that that is true. What do you say about that?
I deny that, Chairperson. I never told Mr. Muhashwa not to communicate with the legal services, and I think I mentioned in the problem is when there are multiple investigations, you don't know where you mentioned the issue, but I mentioned it that because at the JCC, the allegation is I terminated his mandate. But in his own statement before you, Mr. Muhashwa doesn't say that. He says his mandate, he explains who terminated his mandate under what circumstances. So I deny, and I will deny. Anyway, I don't even have to deal with whether I terminated his mandate or not, because in his own words, I'm not the one who terminated his mandate. But the issue of communication with him, I never told anyone not to communicate with him. And as it is being said, Chairperson, it's someone saying, I was told by someone that someone told someone that someone says this.
Yes,
I never had any discussion of that nature with Mr. Muhashwa.
But you did have meetings with him.
The sequence of event with regard to the communication, Chairperson, is there's an email that I took exception to. Here is an executive is asked to explain something, to give information, because it's an information-seeking question. Can you tell me what happened here and here and here? And then he takes that question to Mr. Muhashwa to answer. And I said, there's an email to that effect. This question, I wanted you to answer to me, because before you go and ask outsiders, you need to understand from within.
Yes, but
but that does not amount to me.
You are on another question now. I'm still on the question of whether, on your denial that you told Mr. Muhashwa not to discuss the CIA claims with the legal team of legal department of PRASA. Why would it just seems strange that an attorney who gets work from PRASA and who is working with the new chairperson of the board of PRASA would say to somebody in the legal department of PRASA, your chairperson said I mustn't discuss these matters with you, when in fact that is not so, and when in fact he expects or wants to get more work from this chairperson and and PRASA?
I don't know, Chairperson, but if you were to allow me an opportunity to deal with this statement, because as I said, maybe I have not said it here to you, but we had meetings, and I will deal with what transpired in those meetings when Mr. Muhashwa came to PRASA, and then I think it was me and Mr. Zide was still acting, and the legal team was not there. And I asked, where are they? And I was given an excuse, a reason why they are not there. And I think I say it in this statement. And then the next meeting, where where is Miss Ngoye? She's not here, she's supposed to be here. And then I'm told, I think the excuse then was there was a bereavement at home. And so you, Chairperson, at no stage was anyone excluded or told not to come. And in any event, Chairperson, I am going to deny the version that they have put about what Mr. Mkhashwa told them, that I have told him. And if Chairperson still has a strange feeling, maybe let me answer to the specific allegations, because there is a sequence and of the meetings, what was discussed, and who was there, and what transpired later on, Chairperson. But I'm noting
The areas that I particularly want to hear what you have to say
yes,
on.
I'm noting what you are saying.
Yes.
And I will address it, Chairperson.
Now, you referred to Mr. Botes. Mr. Botes, you referred to the fact that he gave evidence and said you were the first one, you contacted him first
Yes.
about the CCI claims, and it's true, that's what he said in his evidence. You have said that the investigation that has been done by the investigators of the commission suggests that the probabilities are that he contacted you first, and
Yes.
he will get a chance to comment on that.
Yes, I have a statement.
One of the things he said is that in the discussion that he had with you, I think it was the first one, whether he called or you called, but that first one, he said that you said to him that you had been appointed or deployed at PRASA to clean up the mess. Do you want to comment on that?
I filed an affidavit, Chairperson.
Yes, and you deny that.
I filed an affidavit. It's part of the commission's record.
Yeah.
I have already denied,
Yes.
used the word deployed. He said, I told him I was deployed by President Zuma to PRASA, and I said, I don't even know President Zuma. I've never met him. I've never seen, I see him on TV like any ordinary South African, and I said the only time I've been within a breathing space, that's the word I used, with President Zuma is during the inauguration of Dr. Nkosazana Zuma at University of Limpopo last year, and that's the closest I've ever been. I'm not a politician. I've never been a politician. I understand the word deploy is used in those circles. But I said, I also sketched my relationship with Mr. Botes, that I could not have discussed such things with him. We are not close, we're not friends. I don't even know what kind of work he does. He does not even know what kind of work I do. We've never been briefed by the same briefing attorneys or anything. I've never been to his. So it will be strange for me, you know, Chairperson, now when you must also understand, because throughout you kept on using the word, it's strange, it's strange. It's also strange for me when someone would make those kind of allegations to me. And you know, you get to a point when here is this allegation, and then you can only give your version. But to the mind of the next person, it will still not make sense. But he has not, I don't know if he has denied my assertions. And remember, I don't know if he came back to the commission, But I told the commission that this person I laid a complaint against, and he says it was dismissed. I said, I didn't even know it was being considered. He told you that I was invited to the disciplinary hearing. I did not attend. I don't know if he has come back to you.
Yes.
But
No, I understand that you deny what he
yes,
said.
I
but
deny
One of the
everything.
things he said, I might not remember the exact wording, but it related to what you thought of the legal department at PRASA. And if I recall correctly, he may have suggested that you said that they were undermining you or they were not good enough. I can't remember, but he says that's what you said. Do you remember that part in his...
I remember it perfectly, Chairperson. Remember, is the person that made me to want to come and testify because I thought his evidence is out of this world. He used the word, I told him, I don't trust.
You don't trust the legal
I don't
department.
trust the legal team. They want to waste PRASA's money by going to arbitration. They are undermining me. And I denied, and I think in my response, I referred to his email, the email that we read when we started, that he is the person that uses that kind of language when he talks to people. In that email that we talked about, Chairperson, he is the one who was intimidating the legal Mr. Mukhashwa and Advocate Zatawan, calling them, you are on I don't know this word, you are on the frolic of your own, and that kind of language. And you want to waste money. Why don't we settle? Why are we still going on arbitration? That's when we started, Chair, I said, even before I came in the picture, Advocate Botes was persuading the PRASA team to settle the matters. So with regard to the undermining part, I've in the annexures, the WhatsApps and the SMSs that I say I sent, but they have not been bundled together. I have shown in one where he was telling me that the legal team and the people at PRASA, I think even the CFO, were they are undermining you. You are a person of great integrity. These people are undermining you. So he is the one who was telling me that I am being undermined.
How would you have known that they were undermining you?
Remember, he was making inquiries about the payment of the claims. The claims were settled in December, and then there was a period where it appeared there were no problems. And then the legal team said they cannot authorize the payment, which is another thing why it would be strange when the people who are going to implement the payments say they have been excluded, because everybody knows that when it goes for payment, their signature is required at some point. So I then said to Mr. Botes early in January of 2018 that, look, don't make inquiries with me, deal with, I think I actually used the word, let your attorneys handle communication because I can't help you. Then he was persistent, and then I gave him the telephone number of the new CEO, who he he was then communicating with, the evidence is there, Chairperson. When we packaged the documents, you'll see it. Then he was communicating with the new CEO who was promising him that the claims will be paid. So it's in that context when he will be reporting to me that, no, today I've spoken to this person and this is what I said. I said, look, I am quiet because I can see that although they are not saying it out loud, I can hear in the corridors that they are making allegations that these claims should not have been settled. So I don't want to deal with this matter anymore. And that's when you would be telling me that they are undermining you. It's in that context.
Now, you say you deny that. You deny his statement that he said you told him that you did not trust the legal department of PRASA.
Yes.
Did you trust the legal department of PRASA?
I said when we started very well. We had meetings where we were going to discuss certain issues.
Go closer to the mic. Yeah.
We had meetings where we discussed certain issues, and our discussions were open. They were giving me information, and then we.
But did you trust them? That's the question.
At that stage, yes, Chairperson.
Earlier on,
our relationship broke down because I didn't even know they were not supporting the settlement. Our relationship broke down in after the legal panel of PRASA was suspended. There was the board.
That was on the 1st of December when it was suspended, if I recall correctly.
Yes, but then the issues came to head beginning of the year. When the Ms. Ngoye was asked to write a report to the board, and then she wrote that report, which she was not supportive of the decision. The decision had already been taken, and the report was very critical of the board. And then that her report was leaked to the media, and it was then published in some newspapers, and then it was then used by Unite Behind when they challenged the decisions of the interim board. So then that's when our relationship, not just with me, with the board, broke down. So from there,
You did not trust them after that?
Well, I had a conversation with her that, look, the report that you have written to the board, can you say something, because it's in the newspapers and it's being used by people who are challenging the decisions of the board. Can you say something so that this issue can calm down? And then she refused to. She said no, she is not willing to do that because what she has said is correct. And I wouldn't want to use the word trust, Chairperson, because I don't understand the context or the meaning of the word when you say, did I trust her or not? I'm using the word, the relationship between legal services and the board broke down. And then I can't say, because I never had any dealings with them after that.
Yes, you see, we talked about Mr. Potter's evidence that you told him that you did not trust PRASA's legal department.
Yes.
And you said you deny that you told him that.
Yes.
So my question arose out of that to say, did you trust them?
I said in the beginning.
So you can't say you understood what trust means when I was saying Mr. Bottas said you didn't trust them, but you don't understand it.
No,
I ask you whether you
I
trusted
said
them.
in the beginning we had a good relationship. But then after the suspension of the legal panel, there was that discord between them and the board. And I never had any dealings with them. So I didn't use the word trust. I said we had a good relationship in the beginning. And then it broke down, not just with me, but with the entire board. Then until they were working against the board. And I have proof. I will prove to the chairperson that they were working against us. And because chairperson, if they had maybe, because even if it's a board that is not lawful or properly constituted, there would have been someone in the board that they would have trusted to take the problems to, but they never did. And then they were doing their things and then going behind everybody's back until the minister and until the matter is before the commission today.
So, did you involve them in discussing the merits or demerits of settling the CIA claims? Did you have a discussion with them to say, as people who had been dealing with these claims for some time as the legal department before you came, to say, let's talk about the defenses that you are putting up against these claims, and let's look at the evidence. Did you have that engagement with them before you or your board instructed that those claims be settled?
Chairperson, I've already mentioned that in the after that first memorandum, they did not respond to it. They did not respond to the memorandum. They instead asked Mr. Mukhashwa to give a report. And the report that Mr. Mukhashwa was giving was about the pleadings, what they have pleaded in court. But they, and I mentioned it in my memorandum, that Ms. Ngoye appeared to have some faint, they were not aware of what was happening, if I can put it.
Yes, about the claims.
About the status of the matter, that even the insolvency inquiry, the status of the matter, when I inquired, and I say it in my statement, that when a head of and let me correct Ms. Ngoye. Ms. Ngoye does not have, she appears to think she's the litigation manager. She's the head of 3 units, LRC, Legal Risk and Compliance. The legal manager is Mr. Dingiswayo. So if they don't know the status of the matter, Chairperson, and I say it in my statement when I complained about Advocate Bottas, it just shows the negligent manner in which the matter was being handled. And you cannot say, in future, I intended to plead.
But remember what my question is. My question is, did you involve them? Did you engage them, the legal department, in discussing the merits and demerits of settling the CIA claims?
Chairperson, I said the answer I gave, I said I did, and they did not give me a report.
Yes.
Instead, they asked the attorney, the external attorney, to answer on their behalf. I think that's my response.
So is the position that their only involvement in regard to the process that led to the settlement of the CIA claims, was their involvement limited to the fact that you asked for a report from them about the status of the matters, and they asked the PRASA attorney to prepare a report? Is that what you are saying, or do I misunderstand what you are saying?
They asked him to prepare a report, and I said, but then I want to know from you, because yes, the attorney can prepare a report, but I don't know, Chairperson, if they have given you any report written by them to me on the matters. And before I forget, Chairperson, there's a document that I'm going to give you, which is a letter that the board directed should be written to them, to Ms. Ngoye. This is after she had gone to the minister to say, give us a report on these matters.
On the CIA claims?
Yes, on the reports on CIA, on the evidence. It was in effect asking her that since she now says the claims should not have been settled, can you please provide the board with information, reports from the people that you say are saying that testified? Remember, she's challenging. We consulted with those people, but then she says, no, she also consulted. So the board wanted to address the merits.
You're going outside my question. Can I put it this way? From what you are saying, it seems to me that your answer is yes, the only involvement the legal department had in the process towards this that led to the settlement of the claims was when you requested a report, and they got the attorney to send a report, plus what you have added. But in terms of engaging and discussing the merits and the legal issues and why it should be the matters should be settled or should not be settled, that did not happen. Is that right?
They didn't attend the meetings.
Yes. Of course, if they don't attend the meeting, that means
I thought
they did not engage.
I already said that meetings were scheduled, and only Mr. Mukashwa came, and then and remember the reporting lines. They were reporting to the CEO. Yeah. And then I would be asking the CEO, but in this meeting we're supposed to have them, and then he will give a reason why they are not there. Yes. And the meetings would continue. But they had already given that report by Mr. That gives, it was actually a status report to say we filed a plea, this is the plea, and
so who exactly did you involve in discussing the merits and demerits on whether to settle these claims, and if so, at what amounts?
I said in my statement, Chairperson, that there's a delegation of authority. The delegation of authority that I have, that the board, my board was given, is attached in some documents. Mm-hmm. And I've also attached the email from the secretary transmitting that delegation of authority to the board members. And I've also said, the reason I'm saying this is because I see Ms. Ngoye has attached a delegation of authority, which I don't know. But in terms of that delegation of authority, you know, with delegated authority, there would be limits for each person or office incumbent.
Yeah.
So these, the executives, which there will be the legal manager, which is Mr. Dingiswayo, he would have his limit, financial limit. Ms. Ngoye would have his financial limit as the head, overall head of that section. The group CEO would have a limit. Then the board will have a limit. The claims were fell within the delegated authority of a group CEO.
Yeah.
So I deny that in terms of delegation of authority, it was within Ms. Ngoye's authority. In terms of the document in my possession, she did not have that kind of authority. Her authority ended somewhere, and the claims were within the delegated authority of the group CEO, not even within because once it gets to above million, that would be the board. But before not 1 million, 100 million.
Well, don't worry about the figures,
Yes,
because we can
but the
always
point
look
I'm
here.
making is I deny that
Yes,
it was within her authority in
Yes.
terms of the documents that were given to the board. And
Yes.
if there's any delegation of authority that she has, then she misled the board, or someone misled the board, because the one that I have says what I'm telling you.
No, that's fine, but you would be aware that in her affidavit, Ms. Ngoye, effectively, as I understand her evidence, says that the court rescinded the order that it had made on the basis of the arbitration awards that had been given to the CIA companies.
I don't
On the
know.
basis that you did not have authority to settle those claims, because in order to have those claims settled, certain procedural steps had to be taken which had not been taken. You would have seen that in her
I haven't
affidavit.
seen that, Chairperson. I remember when I say I read her overall affidavit, there's somewhere where she says the settlement, the arbitrator set aside the settlement. I didn't get a sense that it was a
Yes.
setting aside by the court, but remember what Advocate Botes says. Advocate Botes says the PRASA did apply to set aside the settlement. The matter was set down for some time, I think.
Well, this is what happened according to the evidence that has been led here.
Yes.
You instructed that the claims, you and your board instructed that the CIA claims be settled, and settlement agreement or agreements, I'm not sure, were concluded. And from there, the PRASA lawyer and the CIA lawyers went to the arbitrator who was supposed to arbitrate the claims, Judge Brandt, and said, there's been a settlement, please make this settlement an arbitration award by agreement. And that was done. And then when PRASA did not pay, even when that step had been taken, the CIA companies went to court to make that arbitration award an order of court. It was made an order of court. And subsequently, the legal department had to approach the court first to interdict the sheriff from paying over PRASA's money to CIA, and secondly, to rescind the order on the basis that you or your board had no authority to settle the matters. That's what she says.
No, Chairperson. Chairperson is reading the documents wrong. Let me correct you. Before, under this case number that I said there's an affidavit, yes, the awards of Judge Brand were based on the settlement. Then Judge Holland Mutter made the arbitration awards orders of court. Then PRASA went to court to interdict the sheriff, because the minute they were made orders of court, then the sheriff attached. I think it was money, not I think. Then PRASA went to court to challenge the warrants, to set aside the warrants whilst waiting to rescind the orders of acting Judge Holland Mutter. That application came before Judge Tukten. Judge Tukten rescinded the orders that made the arbitration awards orders of court. That's when Judge Tukten said the settlement is still in force, and Makuvele will have a day when there's an application to set aside the settlement agreements, because that's where I was involved. But in the meantime, if that enforcement application, you called it enforcement application, to enforce the settlement, is not, there won't be an appropriate forum, then Makuvele, there must be another forum for Makuvele to state a case. So as far as the courts are concerned, that those settlements have not been set aside. And then Advocate Botes says the matter was set down to decide on the fate of those settlements, but then it was removed from the roll, I think last year. That's the status. So
Yes.
that's the status, Chairperson.
But you do accept
So,
that.
but then what was being said, Ms. Ngoye in her affidavit said she is going to join me when there's that application to set aside the settlement agreement. Remember, now I'm the one who acted unlawfully, and without my involvement, obviously, I mean, in those proceedings, if I decide to oppose, and I don't think I would have wanted to get involved, because I don't know, but I say in my statement, I have never been found guilty. That's what why I'm emphasizing that no court has ever found me guilty of anything.
What do you say about the complaint that you were running a board that did not have a quorum? That all of these things that were being done by the board was being done by a board that was not constituted in terms of the applicable act, and it had no authority to do anything until it was properly constituted. As I understand the act, and you must tell me if your understanding is different. My understanding is that your board needed to have 7 members, some of whom had to have certain expertise, but your board only had 6 members, and that the minutes will show that there was no meeting during your time, or rather, some of the minutes where meetings apparently were held show 6 members or 5 members. I don't know whether the meeting of the 16th of March, there was a new member which came. What do you say about that?
There's an application before the Western Cape High Court on that very matter, Chair. I wouldn't want to venture an answer without properly applying my mind to it. It's a legal argument that it's before court, and PRASA filed an affidavit to reply to that. I was not kept abreast. I'm not certain if the matter, but I'm not certain if the matter has been finalized. So
Yes, no.
I wouldn't, I know there's an argument that was placed before court. I will have to refresh my mind about it.
Okay, no, that's fine, because we are not finishing today.
Yes.
But it's something quite important, because my own understanding is that one of the responsibilities of the chairperson of any meeting, including a board meeting, is to first satisfy themselves that there is a quorum before they can do any business, and therefore one would expect that it's
Yes.
something that you would have looked at, and probably you have a view as to whether that
Yes,
what
well,
they say is correct or not.
as I say, I believe there's a legal argument that has been put. I don't want to venture into it. It's quite a long time. I need to read the papers.
Okay, no, that's fine.
And
The last question for today, for this evening for me is, one, I talked about something that I said seemed strange to me. Another one that seems strange to me is that the so-called settlement of these CIA claims, your instruction or your board's instruction was effectively, as reflected in the settlement, was effectively that PRASA must pay exactly in regard to each of, I think, about 4 claims, the amount that was claimed, and the interest that was, the interest, I think, running from the date of service of summons. The only thing that I think wasn't there is that PRASA must pay costs. That didn't seem to me a usual settlement. In a settlement, one would normally see that the plaintiff claimed 5 million, but the actual settlement is less than that, because the parties are trying to settle so that they don't end up in court. Are you able to say anything about that?
not at this stage, Chairperson. As
Not
I
at this
said,
stage.
when I was dealing with that report,
Yeah,
and that the evidence of, or rather the submissions of the relevant people with regard to, remember with some claims, there would have been, the issue is the amount, and then they would have indicated that the correct amount is here, and I don't want to venture an answer without looking into the documents, and but I've noted your question,
yeah.
and your what makes you feel uncomfortable?
Some of this, what I consider to be, what seemed to me to be strange
To be
features.
strange, yes.
Yeah.
But,
Which you might be able to explain, and once you have explained, they might not be strange.
Yes, and I may not be able to explain, but then I you know, Chairperson, remember the submissions by a person who says she is not trying to tell this commission that her quotations are correct, and she's someone who has these strange feelings about documents, and obviously those who were there must be able to explain, Chairperson.
Yeah, no, that's
So
fine.
it's a, but at the end of the day,
It's a way of being fair to you.
Yes.
To say you must know what's
I've
weighing in my mind so that you can address it properly. you
I've
know.
seen that, and I've seen Mr. Mukhasha's response.
Yeah,
Because, when things happen in the presence of attorneys, they would know what to call the letter. Do you write without prejudice, with prejudice? It's a settlement, it's what? And it's things that happen under direction of legal advice. It's
Okay.
only lawyers who would be able to explain the wording, and I would say I relied on this explanation, but I first need to look at the document.
yeah, okay, all right. We are going to adjourn now. You must then remember that next time you must have looked at all the documents that you may wish to look at, so that we can deal with everything. But in particular, you will remember for when we resume next time that you will be among other things, you will be looking at the issue of what work you did at Water Tribunal, arising from the fact that I said the letter that the Judge President wrote to the Minister about the deferment of your appointment gave your work at the Water Tribunal as the reason.
I said I don't have that letter. Can someone?
Yes, no,
give me-
you will get the letter.
Can
The
someone
legal
give me
team-
that letter?
Yeah, that letter, as well as the correspondence from the Water Tribunal. As I said to you,
Yes.
they said there was only one appeal, but even that one appeal was only had in 2017 and not in 2018. So you can look at all of those things.
Yes.
You can also have a look and be able to say, here are cases, I don't know what they are talking about, that I was involved in. And in terms of wrapping up your legal practice, also you give us information. You said you appeared in certain courts,
In
what
certain
you are
courts.
able to give us.
And I will also give you what we were doing at Prasa.
Yes, yeah, do that as well.
Because of this belief that there was an obsession with the one matter. And Chairperson, if I may also say, I did indicate to you that I was reading the rules. There's if part of my response will point to irregularities. Remember, the affidavit of Ms. Ngoye says she wants to highlight where the leaders were found wanting in various reports of AGs, PP, and National Treasurer. And Chairperson, I must say right now that she only talks about me as a person, as if I was there alone. But she doesn't talk about herself. There are irregularities involving her, Ms. Ngoye and Mr. Dingiswayo, which I'm going to talk about and require an investigation by this commission, because once I mention it, there is that obligation. She doesn't talk about the irregularities under the board of Mr. Popom Lefe, which I'm also going to talk about. She only wants to talk about me as if I'm just this little branch that was put there at Prasa with just on my own, without. And she forgets about herself and the other boards that where there are irregularities that have been flagged by the Auditor General. We need to talk about everything irregularities, corruption, maladministration does not change its name depending on who is involved.
Yeah. No, that's fine. We are going to adjourn. I indicated on Monday that I was looking at the 17th of August. I'm going to fix that date, but that may change because the commission will talk to your JP, but you indicated on Monday that you might wish to talk to him as well to see if
Yes.
you can get some leave so that you can attend to this matter properly. So we will adjourn to the 17th, but between now and the 17th, there'll be communication between the commission and yourself and the JP.
Yes.
That date might stand,
Might
that
stand or
date
change.
might change, but everybody will be advised.
I may mention to you, Chair, that I've already sent a communication to JP Mlambo last night that I require time. I have requested that he must grant me special leave, because remember, it's not just this matter. The JSC is sitting in October. So I want to deal with all these matters without the pressures of work. So I'm looking at being released for quite some time to attend to all these matters, because, Chair, I also need to obtain the services of someone to assist me to draft the
Yeah.
affidavits that I must draft. So
Yeah.
I'm going to follow up with JP what his position is, but
Yes.
I don't just want to be released for a
Yes.
week. I want
More
time,
time, yeah.
to deal with all these matters. But we should know
Yes.
maybe before the end of this week.
Yes, okay,
Yes.
no, that's
But,
fine.
thank you,
That's
Chairperson.
fine. No, thank you, Judge Makubela. Mr. Soni,
Chairperson, before
you
we
want to say something?
Yes. Chairperson, before we adjourn, you will recall that on Monday, besides the question of Judge Makubela testifying today, you had raised the question of the status of the legal team, namely whether we would continue our participation or not. And it depended, as I understood it, on heads of argument being filed by Judge Makubela on Friday and our filing heads of argument by Wednesday next week.
Yes,
we would
that
like
still
that
stands,
to
yeah.
stand,
Yeah, that still stands.
because
Yeah.
I must just say it is a bit awkward for me, sitting as the leader of the legal team in this matter, to be sitting as a participant, in this, as a spectator in this.
Yeah, no, that directive stands. So, and as I indicated, it might be that I'll decide the issue, or it might be that I might find a practical solution to it, but that doesn't, obviously if I find a practical solution to it, anyone who would not have filed, there might be no need to file anything, but until everyone is advised to the contrary, that directive about Judge Makubela filing her written submissions this Friday, and the Commission's legal team filing its own written submissions on or before Wednesday next week stands. Okay, all right.
Chairperson, we submit it is an important issue, and I've not discussed it with the other members of the legal team in the Commission, but one can expect that this sort of onslaught on the integrity of members of the legal team is going to continue unless the parameters within which the withdrawal, recusal, whatever one wants to call it, is properly set, Chairperson.
Thank you very much to everybody for staying on until this time. We are going to adjourn. And as I said, the the matter is postponed to the 17th of August at 10 o'clock, unless the time is changed, but the date might change. But until there is a advice that it has changed, it will remain the 17th. We adjourn.